Hello, and welcome once again to another episode of Car Brief. I'm your host, Richard Elsager, a licensed attorney, licensed to practice in the state of Illinois, and I've again dredged up another scary tale from the legal graveyard of automotive horror to bring to you this sordid little tale entitled Henderson versus DeMars. Let's tear this one apart, shall we? This case arises out of the United States District Court of Florida, Southern District. In March 20th of 2013, they came down with its decision. The plaintiff, Robert Henderson, alleged that in February of 2007, he obtained or acquired an interest in buying collector cars. He saw an ad placed by the defendant, a Robert DeMars in Hemmings Motor News, a magazine that catered to the automotive collectors and enthusiasts. According to Henderson, in the ad and website, DeMars presented himself as the world's best-known auto appraiser and made numerous representations as to his skill, his expertise, and diligence in appraisal, inspection, and the diagnosis of classic cars for buyers. Henderson contacted DeMars to assist him in finding some vehicles that spiked his interest. Henderson claims that DeMars thereafter sent him additional materials touting his ability to inspect and appraise classic autos, and in all the advertisements, DeMars indicated that the services would be provided by DeMars Limited. Henderson claimed that no such corporate entity existed, but that's besides the point for the purpose of this case. Henderson executed an auto search agreement, the contract, with DeMars for DeMars to track down and locate high-end cars. Let's begin with the 1974 Ferrari Dino GTS. In May of 2007, DeMars located and had inspected for Henderson a 1974 Ferrari Dino that was painted fly yellow. Henderson saw the car, well, he didn't see the car, but DeMars told Henderson that the car was a time capsule and the condition was one of a kind and all original condition, including the original fly yellow paint. Based on DeMars' recommendation, Henderson bought the Ferrari for $205,000, and a commission was paid to DeMars of $19,400. It's a pretty good commission. The retail value of the Dino was appraised at $300,000 thereafter by DeMars after Henderson bought the vehicle. 2 years later, Henderson decided to sell the Dino through a North Carolina classic car dealer. After that car was inspected and the history researched, it was determined that the car was a repaint on 2 occasions, and the original color was blue, not fly yellow, as represented by DeMars, the auto appraiser. The classic car dealer was able to locate the original owners of the Dino and confirm the car was originally painted blue. Let's go on to the 1973 Ferrari 250 GT Lusso. In June of 2007, a Ferrari 250 GT Lusso was located in Boca Raton, Florida. Now they say in 1963 here, so they've got the dates mixed by 10 years in the opinion. It's hard to say. I think that they probably mean 1963 as opposed to 1973. DeMars told Henderson that the car contained the original engine. Based on DeMars' recommendation, Henderson purchased the car for $485,000. DeMars was paid a commission of $41,000 for that purchase. And then DeMars provided Henderson with an appraised retail value of the Lusso of $650,000. 3 years later, Henderson decided to sell the Lusso, and he shipped the Lusso from North Carolina to California, where the individual that was to buy the vehicle made a visual inspection of the car upon its arrival and noticed some unusual stampings on the engine block. And that led him to perform additional research on the car's history, and then he was able to conclude that the engine in the Lusso was a counterfeit, so it did not have the original engine. In Henderson's lawsuit, he claims that DeMars breached the terms of the contract by failing to properly inspect, diagnose, and determine the accurate history of the cars. Henderson claims the original color of the Dino and the restamping of the Lusso would have been easily detected by a knowledgeable auto appraiser. Henderson further claimed that DeMars violated the Florida Deceptive and Unfair Trade Practices Act, making several deceptive representations in his advertising, his website, and so on. Well, Henderson sought damages in the amount of $19,400 for the Dino and $41,800 for the Lusso, which amounts to the commissions paid to DeMars. But it wasn't only that Henderson sought. He was seeking the consequential damages, as we term it in the law, for damages that resulted from the breach of contract. And these damages were the purchase price paid by him for both the Dino and the Lusso, which were overinflated by 15% based on the lack of original paint on the Dino and the presence of a restamped counterfeit engine in the Lusso. Henderson also sought attorney fees. Well, the defendant, in counter to Henderson's allegations, said that he didn't deny the existence of the contract and he didn't deny locating the Dino and the Lusso and appraising the vehicles for Henderson, but he claims that the Dino and the Lusso were not the only two cars purchased by Henderson with DeMars' assistance. DeMars also assisted Henderson in purchasing other cars, which Henderson later sold at a profit. So DeMars is saying, look, hey, this may have been turned out not the best, but look at all the other good things I did for him. That was essentially their argument. Court wasn't really going to buy that. According to DeMars, experts were used to inspect the vehicles and their findings were shared with Henderson before the purchases. Henderson is also an expert businessman who had purchased and sold classic cars before his relationship with DeMars. DeMars claims that both the Dino and the Lusso were purchased as is and the no guarantees were made to Henderson. DeMars also claimed or asserted that Henderson's use of the vehicles in the years prior to their sale diminished the value of the vehicles and that Henderson decided to sell the vehicles in a bad sales market and did not use best efforts. So DeMars had a good attorney making some pretty effective arguments here. Let's see if the court buys it further. DeMars denies breaching terms of the contract. DeMars represents that he had tremendous experience in appraising and finding the best cars. He also sent a letter to Henderson representing he would act as a detective for Henderson and that no additional inspection, diagnosis, or appraisal fees would be necessary. DeMars described the exhausting procedure and his inspectors would utilize in the research of these vehicles. Well, the court looked at the credibility of the testimony. Experts were hired in this case by the plaintiff. The evidence overwhelmingly established that irrespective of his qualifications, DeMars did not perform the services he agreed to do under the contract. Under Florida law, and this is a law of many other states, please check your local state, breach of contract claims by the plaintiff is required to show, 1, that there was a contract, seems reasonable, 2, that the defendant breached the contract, and 3, the plaintiff suffered damages as a result of the breach. So it's a 3-part test. The facts in this case demonstrate that a contract did exist between Henderson and DeMars. That is, specifically, DeMars agreed to locate and recommend cars for Henderson to purchase. In exchange for those services, Henderson agreed to compensate DeMars. DeMars claimed that the contract only obligated him to locate vehicles. According to the courts, borders on the absurd, to use the court's terminology. DeMars also bombarded Henderson with emails with claims that he was a car detective and he would provide the bottom line recommendation of the vehicle's actual condition and mileage. And this was clearly stated in the contract in several places that DeMars' obligation was to locate and recommend a car for Henderson. Well, pursuant to the terms of the contract and the documents described in the contract, the service included not only finding an automobile, but also inspecting, diagnosing, and making a determination as to the history of that particular car. With respect to the Dino, it is undisputed that the original color of the Dino was blue and not the fly yellow that DeMars indicated was its original paint and color. DeMars breached the terms of the contract by failing to properly perform all the services that he offered in exchange for the commission he received. The testimony of the plaintiff's expert also demonstrated that determining the original color of the Dino was a surprisingly easy task and one that should have been performed by DeMars pursuant to the contract. Anyone apparently could have consulted the Dino registry online and found out in 5 minutes that the original color of the car was blue, not fly yellow. Also, by subscribing to the Ferrari market letter for $75 for a 6-month subscription, DeMars could have obtained a full history of the Dino, including the fact that it was originally painted blue. DeMar's explanation for not knowing the existence of the Dino registry and for not consulting the Dino registry, he said essentially, quote, "I am not an internet person," unquote, and for not continuing a subscription to the Ferrari market letter with no explanation are absurd, according to the court, for someone in 2007 held himself out as the world's best known auto appraiser. So the court just wasn't buying the arguments that DeMar's attorney put forward. With regard to the Lusso, based on the testimony of an expert and the person that was to buy the Lusso, there was a knowledgeable auto appraiser. They indicated that somebody with knowledge should have been easily detected, or should have been able to easily detect that the engine was a restamping and that something was suspicious at the time of DeMar's inspection. Once the suspicions were aroused, it was again easy to learn from a simple look in the internal number of the engine was for a different model of Ferrari. So based on all the evidence that was presented to the court, they found that DeMar's had breached the contract by failing to provide the services that he agreed to perform for Henderson. And when they came to the damage portion, they awarded $41,000 for the overpayment on the Dino, which was 20% of $205,000, and the court ruled that Henderson had overpaid for the Lusso by 20% of $485,000 or $97,000. So the court entered a verdict in favor of the plaintiff for $138,000 for the purchase of these two vehicles. The court found that the contract only allowed for recovery of attorney fees and for any action for non-payment of services or expenses. So the stipulation in the contract over attorney fees didn't apply here because the contract was fully performed and it wasn't an issue over non-payment. Attorney fees were not going to be awarded in this case. So that helped out the defendant to some degree, obviously. As far as the unfair and deceptive practices under Florida law, the court said there wasn't enough evidence or credible evidence that the contract was entered with an intention to fail to perform it. The failures were done with any intent to deceive Henderson. So there was no intent found there. It was a simple, straight breach of contract action. What do we take from this? I would take from this that even when you hire an appraiser to do an inspection of a collector car, you kind of have to do your own due diligence and maybe watch over the appraiser to make sure that they're doing their job, just to be on the safe side. If you're going to outlay that kind of money, you're going to want to get in touch with car clubs and do your own inspection in addition to. It's actually a safety net that's in your own best interests. I would highly recommend it, in addition to getting an appraiser out there to inspect the vehicle. I don't think necessarily that this appraiser did anything wrong per se or anything malicious. He was an old school appraiser, I believe from the 1960s. He'd been doing this for a long, long time, so he really was well known. I believe he still may be in existence, I don't know, as far as doing appraisals. So that's the takeaway of this case, and I'm going to wind this down here. And now the air is cleared, and the rain has stopped, and the clouds are gone. The case is over, and the sun shines once more, until the next legal storm clouds form in another case of automotive terror brought to you from the courts. I'm Richard L. Sager, your host of Car Brief, and I bid you happy motoring and drive defensively. Until then, take care.